Afternoon. This is the monthly meeting of the Sustainable Land Development Code hearing officer. My name is Richard Virtue. I'm the hearing officer. We have one item on the published agenda today. Are there any changes to the agenda?
Hearing Officer Virtue, there are no changes.
Okay. With that, we'll move to the item that we have on the agenda today. It is case number 18-5180, Gerald Olson variances. Gerald Olson, applicant, Siebert and Associates agent, requesting variances from Chapter 7 related to 25% slope disturbance for roads and driveways, significant tree removal, 30% slope disturbance for residents, and variance for building area analysis. The property is within the residential fringe zoning district at 66 Coyote Mountain Road within Commission District 4. With that, I believe we are ready to proceed with the staff report.
Thank you, Hearing Officer Virtue.
The applicant is the owner of the property as indicated by quitclaim deed recorded in the records of the Santa Fe County Clerk on September 22nd, 2003 in book 2662, pages 667 and 678. The lot was created in 1969 and is considered a legal non-conforming lot. The lot contains slopes in excess of 25%, and the only buildable area not requiring one or more variances is located on a ridgetop. The site is accessed through Coyote Mountain Road, which is a private road. The access is at a lower elevation on Coyote Mountain Road, where the road briefly crosses the property. Coyote Mountain Road climbs to the top of the ridge near the applicant's buildable area on the ridgetop. However, the applicant has no legal access at that point, which lack of access has been confirmed in legal proceedings taken all the way to the New Mexico Supreme Court. Initially, the applicant was proposing variances to install a driveway to the ridgetop, but this would have caused excessive scarring on the mountain and would have been visible. Therefore, the applicant decided to locate the house closer to the location where the existing road crosses the property. The applicant requests authorization to disturb 5,753 square feet of 30% slope for the residents, 1,350 square feet of 25% slope for the access driveway and parking, and 10 significant trees located on 30% slope. In addition, the entire site is greater than 25% slope, so the applicant cannot meet the requirements of Chapter 7, Section 717, 1011, Buildable Area Analysis. This section requires that only 50% of any structure may be located on a slope that is between 20 and 30%. The agent states our client's original desire was to construct a residence on a portion of property considered to be a ridgetop as per the SLDC. Chapter 7, Section 717.921 of the SLDC prohibits a structure, residence, to be constructed on a ridgetop, ridgeline, or shoulder unless there is no other buildable area on the property. In this case, there is no other buildable area on the property. However, due to litigation, the applicant cannot gain access to the ridgetop areas and is forced to build in an alternative location. After several meetings and discussions with staff, it was determined by the land use administrator and staff that the proposed location was an alternative area suitable for construction for residents other than the ridgetop areas, which is the desired location. The applicant has addressed the variance criteria, and staff has responded if the variance criteria meets as contained in this memo. Recommendation. The application is not in strict compliance with the SLDC, but this application meets the criteria necessary for granting a variance. Due to the topography of the land, the applicant is unable to build a home on the lot without variances. The site offers limited buildable area due to topography and the lack of access to the ridgetop. The applicant has met the variance criteria where due to extraordinary and exceptional situations or conditions of the property, that strict application of the code will result in peculiar or exceptional practical difficulties or exceptional and undue hardship on the owner. In order to construct any residence on the property, a variance request is necessary. This causes peculiar and exceptional practical difficulties or exceptional and undue hardship on the applicant. Based on this proposal, minimizing the amount of cuts and fills and disturbance of terrain, and minimizing the visibility of the proposed residence, the spirit of the SLDC is met. Therefore, staff recommends approval of the variance request subject to the following conditions. Hearing Officer Virtue may enter those conditions into the record.
You may.
Thank you, and I stand for any questions.
Okay. Can staff address the litigation in the nature of that and the impact on access?
Hearing Officer Virtue, the applicant has submitted documentation from the proceedings that occurred in the litigation, and at an upper point where would be suitable for access, it is blocked off due to another neighboring owner, and there is no legal access through that point, in which, you know, the access he would not need a variance, but due to the fact that they lost in the litigation, the access, the only possible access is through that lower elevation point.
So the problem is they'd have to cross the neighbor's property.
Hearing Officer Virtue, that is correct.
To the ridgetop.
Hearing Officer Virtue, that is correct.
Okay, thank you. That's all I have for now. I may have more later. Is the applicant present? Okay, would the applicant and all those who wish to speak on behalf of the applicant, please identify yourselves and be sworn in.
Wayne Dalton, James W. Siebert, Associates.
Okay, you may proceed to present the application.
Hearing Officer Virtue, just like stated by staff. Just like staff stated in their staff report, the lot was created prior to the SLDC coming into effect, prior to the Land Development Code, which was ordinance number 1996-10 for that matter, and is allowed to have a residence in a driveway on the property. Due to the unusual topography and the limited access, we're basically left with no choice but to request variances to allow him to construct his residence on the property. We are in agreement with all staff conditions, and if you have any other questions, feel free to ask me. I'm here to answer your questions. Just to let you know about the access. We're going to change your mic out, okay? Okay. Better? Okay. Just to let you know about the access, these are the ridgetop areas here. This is this is Coyote Mountain Road. This is where, this is the buildable area here. Coyote Mountain Road goes up into here, goes up into some other properties. And in order to access these ridgetop areas, like staff said, you'd have to go into the neighboring properties, which he's already gone through litigation, lost that battle. So basically left with no choice but to access here, which would basically limit a lot of disturbance. If you wanted to come, if you still wanted to build on these ridgetops, you'd have to come from here. So therefore,
sorry to interrupt, but we couldn't hear open speech. We don't hear people's names. We'd like
Okay.
it to just be repeated. We
Okay.
can't hear any of this.
Can we check on what's happening?
And the sound comes in and out, but we'd like to have the gentleman repeat.
Sure.
I think it was the
We'll do
microphone
that
thing.
as soon as we get it fixed. Oh, okay. Can
Somebody
somebody
start over?
Yeah, why don't you do that? But let's, couple of things. You have your mic on now.
It's on now.
Okay. And then can you identify what you're talking from there? That's not in the document you're speaking to is not in my packet. So I'd like to identify it for the record. If you could. Do you have it identified? Do you have extra copies?
Hearing Officer Virtue, I believe it's in your staff report. And that would be page
Hearing officer, that's NB 17 on your packet. It's the actual engineer drawings.
Okay, NB 17. My NB 17 looks different, but it may be because the document is far away. So when you begin again and summarize it, just identify it as that, and I'll see if I can follow it from my packet. Okay.
Okay.
So do we have a confirmation that the folks in the other room are able to hear? Okay. Okay. So we
Okay.
just got
So-
confirmation
okay.
that the persons attending the hearing and are listening from another room can now hear. So please begin from the beginning, if you would, Mr. Dalton.
My name is Wayne Dalton. I'm with James W. Siebert and Associates, and we represent the property owner. Hearing officer Virtue, like I said before, the property was created prior to the effective date of the SLDC going into effect. It was also created before the old land development code, which was ordinance number 1996-10. And being that it was created pre-code before 1980, it is allowed a residence and a driveway. Like staff said in their staff report, due to the unusual topography and limited access of the property, we're here requesting these variances. Basically, don't have any other choice for him to build his residence on the property. We are in agreement with staff conditions, and we are available to answer any questions you may have. Like also, hearing officer Virtue, like John stated, staff stated, the applicant cannot access those ridgetop areas that we are showing you due to
Just clarify,
litigation.
you're talking from Exhibit 2 to the staff report, which is NBA 17.
NBA 17.
Okay.
So the applicant could not access the buildable areas on the property because of that litigation that was lost. Therefore, he has no other choice but to build at this alternate location that was chosen by county staff.
Where was the access denied in the court decision? Just pointing towards the map. What?
Hearing officer Virtue, I believe it was up in this area here. I know the Coyote Mountain Road runs through a neighboring property. And that's where it was denied. Access was denied is through that property.
Okay, so to get to the ridge top from another point, you were pointing to the left side of the map. What is the issue with getting the ridge top from that area?
Hearing officer Virtue, in order to get up to these buildable areas from that point, it would be a tremendous undertaking, basically meeting grade, 30% slope disturbance, significant tree removal, not to mention visibility, scarring. We did have several meetings with county staff to discuss that. And basically it was agreed that that was a suitable area, which our client agreed to.
Okay. And how big is the lot?
The lot is 20 acres, a little over 20.
Is that showing
This hearing officer
NBA
Virtue,
70
this,
showing the entire lot?
this, yes,
The building site is in the
yes,
upper left-hand corner of the
that's correct.
on the NBA 17. And so staff met with the owner, and there was mutual agreement that this location causes the least disturbance.
Hearing officer Virtue, that is correct.
Okay. Does the applicant have anything else to present at this time?
Hearing Officer Virtue, not at this time.
I don't have any further questions at this time. I understand we have some folks who've been listening in the other room who want to testify. If they could come in now, please.
Where would you like me? Right there? I need one.
Oh, okay. I don't know if this gentleman.
No, they're just making sure we find the room because we don't know, we haven't been here before. Hi,
Hello and welcome.
thank you.
We have two additional people who've joined the hearing at this point. Let me ask you, are you speaking in favor of or in opposition to the application?
I am speaking definitely in opposition to the application. My name is Susan Kennedy Zeller, and I live at 71 Coyote Mountain Road.
Okay, would you please be sworn, allow the
Raise your right hand. You swear affirm the testimony you're about to give is the whole truth.
Absolutely the whole truth. Thank you.
okay. Please proceed.
I'm going to read it pretty much because I did send through some notes to Mr. Lavatia. I am not cognizant of slopes and percentages and things like this. I'm an art historian, and I work with Native American and Australian Aboriginal and other indigenous arts. So that's what I'm coming from. I agree with all the concerns that my neighbors are going to be expressing later on. My home is closest to the curve in the road that this proposed property construction, and this proposal has many problems pertinent to my own home as well as our close community. Number one, removal of native trees. I do have a second home on Long Island, which is what my organization there is organizing, giving away 10,000 native trees. Managing runoff water and soil, they're home to a myriad of birds, burrowing wildlife, beneficial insects, and they create a balance of nature. To destroy any of them is damaging our total environment along our neighborhood. I see no contingency plan for replacement of the proposed removal of trees. Second point, NAGPR, Native American Graves Protection and Repatriation Act. I was curator of Native American art for the Brooklyn Museum. In this position, I was involved with numerous consultations and repatriations of articles and human remains to Native Americans under NAGPR law. What contingency has been made for a proper examination on this property's potential based on it located near the old Santa Fe Trail to do a thorough archaeological study before any construction is done? Also, it's only 13 miles from a major Civil War battle in which Native Americans as well as non-Native Americans fought, and their artifacts may be involved. Water. There's nothing on the plan that we have for where this construction, if approved, plans to attain its water. The roadway. Coyote Mountain Road is a private dirt road which we, all along the road, maintain as a road association. The applicant has never contributed to helping maintain the road below or above the gateway along his property, despite owning this parcel for several years. Water runoff. Along the front of my driveway, and I would be right next to where he wants to build across the road and down the hill. I have had water run off, digging deep pathways along the side of the road that stretches along my property and down as low as the community roadway. Despite having a culvert built, and I've repaired this 3 times in just the short period of time I've lived there, I see no contingency in these plans for handling water runoff. The roadway itself. How will any new owners, and I don't believe the person applying is going to be living in the house, we have no indication that way, but how will any new owners contribute to the upkeep of existing roadway above and below the security gate that exists now? Things like water damage, snow removal, gutters, basic road bulldozing to maintain the quality of it. Security. I have extreme concerns about any constructions at that spot itself. It's common knowledge that construction sites can be rife with thief and mismanagement. How is security, if it is approved, going to be handled to be built here? There's no mention of security provided for those of us living along the roadway, and especially myself. I'm a widow, I live by myself, and I'm right next door to the proposed construction. Builders would have 100% access to all of our own properties at all times based on this proposal. The security gate. What plans have been made to maintain our security gate should construction make it break? The present owner does have a code to go in and out because that is his right. But so far he has never contributed to maintaining the security gate when it breaks. I and other people who are beyond that gate do take care of that. So how will construction manage giving us security, not breaking our gate, and if it does break, repair the gate? And lastly, parking. It's a very, very narrow area. There's no large spot. Where would construction vehicles be parked so as not to impede access for all who live above this area? Thank you for your consideration of these serious issues that I brought up concerning involving any construction on this particular parcel. If anyone wants a question for me, I'll be glad to answer.
Ms. Zeller, when did you first find out about the application?
The yellow sign was posted on the curve of the road, and because I go by that curve, because I'm right next to kitty corner from where he's proposing, I saw the yellow sign. I took a picture of it and emailed it to our association, our neighborhood association.
Okay, and that was posted approximately 2 weeks ago?
No, maybe only a week ago. And then letters were sent to everyone on the road, but, and I do have 2 addresses. You sent it to New York and not Santa Fe. Or not you personally, but whoever sends out letters.
Okay. And have you had any contact with the staff or the applicant about this, about the variance, any discussions?
I've never met the applicant whatsoever. He's never introduced himself, come up to my house or anything.
And none with the applicant's representatives who are here, the folks who are
Nope,
here today?
never.
Or the staff people who are?
Because we're a close association, we had people within our association on the roadway volunteer to contact the staff with sort of multiple questions that we had, rather than us coming at you asking the same question all the time. So one of our representatives asked the questions and then shared the answers with everybody.
Okay. I'm going to ask staff to address your concerns in a while, but I think what I want to do is have everybody who wants to speak on this speak, and then we'll have the staff address what your concerns. So, do you have
Great.
anything else you'd like to present?
Nope, I'm fine, and we have other people in our group but along our road who'd like to talk to you.
Okay, fair enough.
We had no idea where we were going.
Okay. So please have
Next person?
the next person come in.
I can do
yeah.
that, absolutely. Too many wheels on that.
Yes, sir. Would you please identify yourself, name and address, and then we'll have you sworn in.
Excuse me, Paul A. Rapaner. I'm at 44 Coyote Mountain Road. I am the house immediately below the construction.
Sir, before you speak, can I swear you in? Raise your right hand. You swear affirm the testimony about to give us the whole truth.
I do.
Thank you.
You may proceed.
I'd just like to start with some of the point you made right at the end of the last thing. Given the turbulence of this, and from our viewpoint, the significance of this construction, it seems odd. I have got no notification, no visits, etc. Where the sign was posted, you couldn't see it if you lived on the premise on our community, unless you were in one of the last two houses going up. So we were ignorant about that until we got it emailed by ourselves. So in general, the process has been very awkward. Reacting to that, from a testimony viewpoint, I feel if I could just do this in English without charts for a second. If you came to my property, these are 5-acre properties in our community. The house I'm in is, in essence, up against, at the back of our property, up against the property that we're talking about. And therefore, I'm relatively close from a construction viewpoint where it is proposed. It will be a major change in the notion of where we live from being, having some space around yourself to being much tighter. But on a practical base, my biggest concern is things like runoff. Nature has served the mountain rather well over the years, and there is natural runoff. There's a chart that somebody had that I saw that had green arrows on it where the water was flowing. If you put my house there, you'd see that it was flowing right up against my house. I have worked over the past 15 years, I've lived there for 15 years, to develop my own little runoff spots to kind of avoid the house. And also ensure that it's distributed, because where this house is to be built is right above what is now all rock, like about a 20-foot drop to an arroyo. That's caused by the drainage from above, which comes down like literally where this house is planned, the proposed house is planned, along the road there, and then onto my property right at near the gate, about 10 feet from the gate. So the Coyote Mountain Road is going north, east at that time straight up, and if you went off the edge, you drop down 20 feet and be on rocks, big rocks. That has gone down about 15 feet since I moved in, about a foot a year, the natural erosion there. That arroyo then goes down and across the road, past another neighbor's house, et cetera, et cetera. So I'm not so sure what's going to happen. I'm very concerned about erosion and the runoff from the mountain. The second thing is it's a hypersensitive area. I'm not a tree hugger. I care about trees, and it's a pinyon forest. And on my property, which is not quite as slopey, it's still slopey, but not as above, if I so much as want to trim a tree, a pinyon, it's 50-50 that it'll die. If I just trim off like the top or shape it on the side for fire reasons. And the reason is because of the slope, they are very tender in their growth and very slow growing. It's a hard place when you talk about replacing trees. I don't understand where they could be replaced. In other words, it's all like rocks and what's there is there. And well, we're going to take down these trees and we'll replace the trees. I mean, I'd just like to know where the trees might be placed. Because if you come visit my house, I can walk back and you can point to any place you want, but it's just not realistic. We're not on a verdant plain somewhere where you can just plant some trees, or alternately plant trees 10 miles away for the oxygen but never addressed the issue of water runoff and drainage. So that's what kind of worries me a little bit. It's just the change in dimension. Where the house developed, as generally was assumed over the years, this is all prior to me, on the top ridge, which makes sense because then you can see around the world, and that's why the property was originally developed, I guess, that way. That would be one thing. But to move it from up here down and then tuck it in this corner as the only place it could be, that corner is rather pragmatic in relation to the implication directly to my house and the drainage. And specifically, I'll use the word cosmetically, it doesn't make sense in areas of 5-acre property to have this variance allowed to be placed in the corner. So were we participants in the discussion whenever everybody, the staff, the owner, everybody had discussions, I think these things could have been better understood at that time. Now we're just kind of jumping in reaction to potential variances. And again, I don't think the notification process was correct. I don't have any information, engineering-wise, other than what we, the neighbors, pass around to each other. But I don't have any package that says this is what's going to happen. So in a general sense, I'm reacting to what I believe is going to happen. And I hope it doesn't happen because it's not a practical answer to the community. I just think the echo impact is big. The community impact is big. Honestly, we don't have a relationship with this chap. He hasn't tried ever to say, hey, I want to be your neighbor. I think it's probably a purchase on his part just to build something to get something out of the land and sell it commercially to another party. But my concern is the building, whether it be that person or another person. That's, I think, what's in my heart.
Thank you, sir. We appreciate your input.
Any questions?
Any questions? Okay. Thank you very much. The next person who wants to speak, please come into the hearing room.
The next person,
Yeah, they know how to do it. They should hear it.
They should be able to hear it.
Maybe we can get them to pre-stage.
yes.
Or would you like them to pre-stage? I'm sure they will.
I asked them too, but they said they wanted to hear it, so they said 30 seconds.
Attempting to make this brief, but they were planning to walk.
Alrighty. Oh, we had a little problem hearing him back there because he was back here, so I'll talk up here. Thanks. Hi,
Okay,
everybody. Hi.
Thank you.
Hi.
Welcome, and
Thank
please
you.
identify yourself, but for the record, name and address, and then we'll have you sworn in.
Got it. My name is Michelle Kirk. I'm at 49 Coyote Mountain Road, right below the property. So just think of it up here and me down here. He's right. He'd be building right above me. Okay. Yes. Raise your right hand. You swear from the testimony about to give us the whole truth. Yes, absolute truth. Thank you. First of all, I'd like to offer these photographs of the property, just for a little bit of idea of what the property. We took these last Sunday, so they're very recent pictures.
Okay, just for the record, I'm going to mark these as hearing exhibit number 1.
Great. Okay.
And I'll give them to the staff, give a copy to the staff, and please pass it to the applicant so they can look at it. And if there's no objection, we'll put it in the record.
I have just 2 questions at the beginning here. Is this going to be this man's residence, or is he doing it for just development? I mean, and to sell?
I'd ask the applicant's representative to address that.
Hearing Officer Virtue, to answer that question is I can tell you, as far as we know, the applicant intends to build a residence for him. That's what we know.
Okay, thank you.
Okay, and also I heard from a previous testation here by the people that have come for the Mr. Olson, that it said that they were going to be taking down 10 trees. Is that correct?
Hearing Officer Virtue, that is correct. 10 significant trees.
Okay. I walked on the property for the first time last Sunday, and 10 trees, we started laughing the minute we walked onto the property because we had heard that too. And there would have to be way more, like 50 to 60 trees, way more than 10 destroyed to be having any kind of possibility of any kind of pad or driveway or anything at this particular property. This is densely forested property with large old pinon trees and a lot of other, trees of the mountains up here. The area, I was shocked because the area was extremely steep. When you walk on, in fact, it was so steep that like you could barely, at times I could barely walk up it. I had to kind of like, here, hold my arm, pull me up, one of those kind of things. I'm going to have to contest the degree of slope on here. Someone said that it was 30 degrees. I have to say it's more like 45 to 50. And if any of you wanted to go walk out there, you'd see that. It is literally right below the ridge line, right below the ridge right here. And the property is extremely steep. I wanted to just read out this, and I'm sure you may have read this, but this will take just a second and then I'll be done. It said, we have personally seen and felt the impact of increased rains in the past years. The runoff from the mountain has increased significantly. We returned home last April from a 2-week vacation to find an almost inch of dirt had flowed down from the mountain onto our patio. The significant removal of trees on Mr. Olson's property will only increase this water flow to homes, which I call downstream, just anything below it. I had occasion to take some photos this past weekend of the property in question. We were shocked at how steep it was. Grading and tree removal of the significance that Mr. Olson has stated, which he has understated, we feel, would have a serious and impactful consequence to not only the integrity of the of the mountain itself. Significant boulder removal would also have to take place as well. These boulders along the dense trees literally hold the mountain together. Removal of said natural resources would, in my opinion, significantly alter the structural integrity of the entire mountain. Our little Coyote Mountain Road is a dirt one, which is already significantly damaged each time we have a heavy rainfall. Taking away the very things that protect not only the road, but the houses in the road themselves, the houses on the road themselves, would, in our humble opinion, do irreparable harm, causing significantly more expenditure to the maintenance of the road. Mr. Olson has had one option plan for the development of his property back in 2003. When faced with the restrictions to this plan, at the time, there were no other options. It was just going to be the ridgetop building. There were no other options. But he has now suddenly found another suitable option. The second option is not in any way suitable to the current codes that Santa Fe County has so wisely passed. These codes are there to protect home and landowners from a situation just as this one. We would humbly request that these variances not be allowed to pass for our beautiful and fragile environment up there on Coyote Mountain, but for the safety and protection of the current residents. Thank you so much. I really appreciate your time.
Thank you, Ms. Kirk. I would ask you to describe what the photos you handed out, which I had marked as hearing exhibit one, what they are depicting.
I came into I entered the property from directly behind the yellow sign, which is where the yellow hearing sign, which, just in my opinion, that was rotten for them to put it there because nobody could see it. Only 2 houses could see it. And so we walked directly in, just straight in, okay? And which is because this is going in that direction, this proposed pad, okay? And there were just huge boulders, massive amounts of trees, over 6 inches. By the way, someone told us that they were not allowed to take down more than a certain minimum of trees that were 6 inches in diameter. Many more than 6 inches. I even had my tape measure with me. If anyone would like to go up there, I'll lend them my tape measure. But then very shortly into the property, there's what you call probably, I'll call it a natural arroyo, just from rainfall, just from watershed, okay? And this particular, you hit this particular first little arroyo at probably about 25 feet into the property, no more. And let me tell you, when it rains up there, that water comes barreling down that mountain, barreling, let me tell you. In fact, we have an arroyo behind our house that I went to once, and it looked like a massive flowing river. Like, it was insane. Like, you would not be able to cross it. It was very, very heavy flow. And we're just worried that when they strip all of this and these arroyos become flat, and this water now just runs straight down onto all the houses that are right below it, which is basically where a lot of the houses are grouped, and then houses below that we're going to have a huge problem. And then we'd like to know, when all this damage occurs, who's going to pay for that? Also, there is absolutely no room whatsoever on that road for parking construction vehicles, massive pieces of equipment. This is a tiny little fragile dirt road. And one time we had people up there, and a guy came down and lost his brakes and smashed right into our front fence. And what do? The guys jump out of the trucks. I'm sorry. I'm like, yeah? Who's going to fix the fence? We have no concept of this whatsoever. Nothing has been said to damage to surrounding properties, possibly during this building at all. Nothing has been addressed. We've never met or talked to Mr. Olson whatsoever. We have nothing. So he's never contributed to the road in any way. We've all contributed to it for years and years and years, and that's all I have to say. So sorry. Continue.
Okay,
Thank you so much.
Is there an objection to entering these photos as hearing exhibit 1 into the record? Hearing none, I'm going to allow them into the record. Thank
The
you.
question you asked, those photos are being taken like due south.
Yeah, yes, they're due south, exactly. Exactly, Jim. Yeah,
Thank
due
you.
south.
Thank you for
They're
that
going
clar-
straight across the length of the property. So
Okay.
just straight this way, and then looking up too. When you look up, you couldn't climb up, you couldn't walk up it. You couldn't climb up it. It's so steep. You literally couldn't do it. Someone would have to pull you, or you'd have to have, big stakes. And may I also say that this man right here has been wonderful to everyone. He's been very responsive. He's been excellent at answering questions, and I just want to give him a pat there. Okay. Thank you very much.
Thank you very much, Ms.
Okay.
Kerr. Okay, so hearing exhibit 1 will be admitted, and we will ask the next person to come up to the table and give their testimony, please.
Hello,
If you would identify yourself by name and address.
Evelyn Kennedy and Malcolm Bob McPherson. We're at 34 Coyote Mountain Road.
Okay.
Can I get you both to raise your right hands? Do you swear or affirm the testimony about to give is the whole truth?
Yes.
Yeah, thank you.
So our property is the property below Mr. Olson's property. So we're contiguous to the 22 acres that we're talking about. And Mr. Lovato was wonderful to meet with me and really made me feel better about the fact that there would not be a road going up behind my house. The property behind us is extremely steep. I think people were talking about that. The proposed plan would be not right directly behind us, but the previous plan, which was the road that was going to switch back and forth up to the buildable lot that he doesn't have access to any other way, would be a switchback right behind my house. So I think I mentioned I'd have to put curtains on my bathroom window, but not to be funny about it. But the idea was that there would be a road behind my house where it is extremely steep. We used to walk that property up over the hill and down into the 80-acre property that's beside us. And we can't do it anymore because we've aged and it's too steep. And I would use hiking poles, and I've slipped and I've fell, and we don't do it anymore because it's so steep. So I understand that the road would have to switch back several times, I would think. So that's one of our concerns, the fragility of the area. Now, the building site, we tried to walk it, and it was extremely steep, but I think that one of my neighbor who was in here, Michelle, explained that. So our other concerns, would be any direct or disruptive impact to our property as a result of any development of the lot. So that if a road was being put in, for example. And then Bob has looked at some of the slope scales. And again, I don't understand all of that, but to us, it seems unlikely that there would only be a 5-foot restraining wall there, that the visual impact of this would be something that, we would see every day coming home. So I don't know if there's been a visual impact study done, if that's required, if that's one of the variances that's being asked for. It's just something that I'm concerned about, the visual. We have, we've been in our house, I think we're one of the only 33 years since April of 1987. So those are some of our concerns. And I'm concerned about how many variances are being asked for. There's 4 variances. I don't know if that's normal or if that's an unusual number of variances to be requested. And I don't know, how much variance is being requested. Is that something that's, are there any standards for that? We have so many questions about this. Is this something that is being done just to provide a buildable lot on a lot that doesn't have another buildable lot? And is that right? That to me doesn't seem fair to the property, to the landowners, surrounding there. If there is no other buildable lot, do we create one by destroying the landscape in a way that causes damage to other people's property? So that's some of the stuff. I think a lot of the other stuff has been mentioned already about the equipment used. We had to blast. Someone said there'd be no blasting, but when we built our house, we had to blast to run the electrical line and the water line from our property to where, well, just on our property where the electrical post was. So there would be blasting, and I don't know what damage that would do. What other things did we have, Bob? The significant trees was a concern, and we, Andy, I think, mentioned how difficult it is. We've had a number of trees destroyed when we had renters in the house for a while with salt being used on the driveway. We had, I don't know how many hundred of trees that were destroyed, and it's very hard to get things to grow. It's not, the soil is dense and hard, and water doesn't stay. It seeps, well, some of it steeps, but it runs off. We have gullies and washes throughout the property. Luckily, our house is between them, so that it hasn't affected us directly. Anything else, Bob?
I just want to mention that the proposed site for a building is very, very steep. We walked it, and it was difficult to walk, and there was directly beside it a huge drainage area, maybe 10 feet down and 45-degree angle. It was really, really steep, and lots of trees. So the 10 significant trees is misleading.
Yeah, and I think we've never heard, we haven't had any contact with Mr. Olson recently about this current project, but at one time you did. At one time, I think he wanted to develop the land. So our understanding is not that he ever wanted to live on this property. He was going to divide it. He told, well, you should say, because he didn't, it's hearsay for me to say it, but
I ran into him on one of my hikes at least 20 years ago, and he had either just bought it or was in the process of buying it, getting it for probably free. But anyway, the ridge top is, as Siebert has said, is buildable, but the place that is currently addressed, I don't think is buildable.
But he was gonna divide it into, that was the thing, he was planning on dividing it into 4 or 5 separate lots. So our understanding was always that he was a developer, not that he had planned to build a residence there. So I think that's all, unless you
Okay.
have any questions.
Thank you very much for your testimony. We appreciate it.
You're welcome. And he's been wonderful to all of us.
Do we have anyone else in the other room that would like to come to the table?
There's 3 or 4 over there. Might be. Just so you know, I was going to speak about it.
Okay. Welcome. Please identify yourselves for the record, and then we'll have you sworn in.
Okay. My name is Ann Lehman, and I live at 43 Coyote Mountain Road. Do you want to introduce yourself to me?
Yeah, I'm Alan Suits. I'm Ann's husband, and I also live at 43 Coyote Mountain Road.
I would like to swear you guys in. You can raise your right hand. You swear firm and testimony about to give us the whole truth.
Yes.
Yes.
Thank you.
Okay, please proceed.
Okay, thank you. We submitted a letter to John Lovato, and so I think that's in your files. But I'm just going to paraphrase a few of the points. And the first thing that I don't think anyone has mentioned yet that concerns all of us is, what is the water source for this land? Because I haven't heard anything about that, and that's crucial. And we don't want a development to start and then find out there's no water. So what would be our question is, what is the procedure for that? Do they have to prove that they have a water source before any variances are granted or before any development can begin?
Does the applicant like to address that at this point?
Mr. Hearing Officer Virtue, for the variance process, no, we do not have to prove a water source. At time of permitting for the residents, at that time, we would have to prove a water source, which will be a well for the property, will be a well for the water source.
So does that mean that they can build a road and build a pad and then find out there's no water?
Mr. Hearing Officer Virtue, I can say a permit will not be granted without proof of water. If the property owner were to drill a well and it was dry, I guess that would just be, I don't know how to answer that question right now, to be honest with you.
Okay.
Does staff want to comment on how the water source would work in this situation?
Hearing Officer Virtue, prior to issuance of a development permit, the applicant would have to submit a permit, a well permit from the state engineer's office. And for a residential development, the property owner is not required to do any kind of water studies to show that there is adequate water available. As long as they have that permit from the state engineer's office, we would accept that as a water source.
Okay.
Some of our other concerns, as have already been mentioned, are erosion and runoff from the site, removal of trees and other vegetation. We've mentioned trees, but we walked the site, and there are also quite a few chamisa bushes, yucca, cactus, undergrowth that takes quite a while to regenerate. So our question is, how would this be handled in terms of, and they all help to hold the soil in place. So erosion is a real problem. Water runoff, damage to the road and properties. I measured the elevation, and from about 34 Coyote Mountain Road, which is the upper part of Coyote Mountain Road, up to where the proposed pad is, there's a difference in elevation of about 150 feet. And in heavy rains in the summer, the water just rushes down the mountainside. And even with all the things we've done, put in culverts, water diversions, and frequent gradings, we still get huge ruts in the road sometimes. So any addition to that is a real concern for all of us. And because this property is on a slope, you know, we're obviously going to get more runoff as if it's developed. Okay, there's also, of course, the problem of damage to the road by construction vehicles, and that would need to be addressed, and needs to go through a private security gate, and that would need to be managed with the people who own that. The road, I really think that everyone should go up and look at the site. The road where there will be entrance to the site is the most dangerous part of Coyote Mountain Road. It's a sharp right turn, very steep, and there's virtually no shoulder on either side. So that is a real problem. What are construction vehicles going to do? So those are our main comments. And the other thing I would just like to say is, this process has been difficult because we really didn't get much information. And I feel like anyone who wants to develop in an already established community should in some way communicate and reach out and give some information. And really, we had to do all the legwork ourselves to find out anything. All we saw was the sign, and some of us got letters, but that was even sporadic. So those are my comments.
I'd like to just add, there were a lot of letters sent to the committee by all the homeowners on Coyote Mountain Road. I'd say it's virtually unanimous among the homeowners that they don't want these variances to be granted. We've lived there for 19 years. I walk up and down that road virtually every day, even when it's raining and snowing, and I have a real intimate idea of what happens when we get a lot of precipitation. And the last few years, I don't think it's merely anecdotal, but we've seen an enormous amount of increase in torrential downpours. And the effects on the road, which we are constantly battling and trying to patch up and mitigate, have just been getting worse. And I think disturbing this particular site, and with the proposed plans that the applicant has for this building site, I think it would be pretty near impossible to guarantee that a lot of that runoff isn't going to increase exponentially. I'd just like to ask, please, that everybody read the letters we sent. There's an awful lot of details. There's an awful lot of concerns. There's stuff that maybe we haven't been able to cover verbally here. But if you would give us the consideration to look at those letters carefully, I think you'll see there's a really strong case not to give these variances.
Okay, thank you very much. We appreciate your testimony. Will you notify the next people that want to come in and have them come in, please? Yes, Mr. Dalton.
Hearing Officer Virtue, if I may say something. Everyone seems to have the same concerns. And if you look at the staff report under the recommendations, under the conditions, basically all their concerns will be addressed at a later time. These issues can't be addressed here at this meeting. The applicant has to go through this process in order to provide staff with all these documents under these conditions. The applicant can't spend all this money on engineering plans and landscaping plans and drainage and grading plans if these variances aren't granted. So I just want to let everybody know that their concerns are being heard, but at this time, I think staff pretty much has it covered under their conditions of approval.
Okay, I think, Mr. Dalton, let's let the public testimony continue and conclude, and then I'll give you an opportunity to address that, and also I'll give the staff an opportunity, and we'll go from there. Okay. Please identify yourself for the record.
Robert Beers.
Mr. Beers, would you raise your right hand? Do you swear from the testimony you're about to give us the whole truth?
I do.
Thank you.
Okay, please proceed.
Hearing Officer Virtue and members of this group, thank you for the opportunity to speak before you. I'm a 20-year resident of the Coyote Mountain Road, and I want to point out that you have heard this issue of stormwater runoff and erosion repeatedly from the people before me that spoke, and I'd like to dig into that a little bit deeper. Probably the most impactful conditions affecting stormwater runoff are the topography and the vegetation on the site. The greater the slope, the greater the potential for erosion because of the energy in that runoff. The less dense the vegetation, the less potential for absorption and retention of stormwater and sheet flow on a site, and the more likelihood for runoff from the site. So this proposed site has both very steep slopes, as you've heard, and it's very sparsely vegetated. So those two conditions exacerbate runoff during precipitation events. So accordingly, stormwater management, both during and post-construction, is critical to mitigate the potential impacts to the existing hydrologic regime of this subwatershed. There are, fortunately, tools to address stormwater runoff. The two I'm familiar with are the Federal Clean Water Act stormwater pollution prevention plans. These are required when the disturbance on the site is greater than 1 acre. According to Mr. Siebert's conceptual plan, the disturbance on this site will be approximately 8,300 square feet, far less than the approximately 43,000 square feet in an acre. Therefore, this site would not be required to have a stormwater pollution prevention plan. However, when I look at this conceptual plan from Mr. Siebert, I notice that it's missing a substantial number of disturbed areas. For example, there is no obvious reference to the septic tank and the leach field that would be required. In addition, pursuant to the Sustainable Land Development Code, a stormwater management plan would be required by the county, and that plan would need to have stormwater management controls for post-development. That is, there would need to be retention structures, detention basins, swales, roof catchment and storage, etc., for the project. When you add those additional disturbances in, I'd like to see what the final disturbed area would include. It might just bring it up to the 1 acre foot requirement for a federal stormwater pollution prevention plan. And I'd like to also point out those pollution prevention plans include construction laydown areas, equipment storage areas, so it's much larger than the actual footprint of the house and parking and garage and driveway access. Something to keep in mind. I think it's important that the actual disturbed site be recalculated as plans progress. In addition, I just would like to confirm with Santa Fe County that the County Ordinance 216-9, all of the stormwater management requirements would be in place for this project.
Hearing Officer Virtue, what happens is he will be required to comply with all of 717, which is our terrain management guidelines, meaning that his pre and post calculations on stormwater drainage can exceed what's pre and post basically in any storm event. So that'll need to be a requirement and will be at the time of building permit.
Mr. Beers, does that answer your question?
Yes, that does. Thank you. So I just want to close with an emphasis that, as you've heard, runoff from the site is a huge concern for the neighborhood. I think a visit to the site would illustrate, given the steepness of the slope, the low vegetated cover, the nature of the soils, that this is a highly erosive site and needs to be addressed.
Okay. Thank you very much for your testimony.
You're welcome.
Could you notify the next person that we're ready for them? Thank you.
Two more than myself.
Okay. Please identify yourself for the record, and then we'll have you sworn in.
Yes, Hearing Officer Virtue. My name is Bryson Innes. I live on Coyote Hills Lane, which is the side road off of Coyote Mountain Road.
Raise your right hand. You swear from the testimony you're about to give us the truth.
Yes, I do. I've been a resident on that mountain for a little over 30 years. And the development that's being proposed is a little disturbing for obvious reasons you've heard from my neighbors. We've seen development, and we don't have any problem with building houses in our mountain. That's obvious that the neighbors are accepted. But this particular development came across relatively suddenly without a lot of details to us. And there were concerns for a variety of reasons you've heard. Everything from the erosion and the visual impact, the road destruction, and it is a very obviously very steep area that they're planning to build on. One of the main concerns is that this particular building site is basically being created out of a very steep, rocky, tree-covered area that, there really isn't, hardly a flat area on it. They're going to have to dig into the mountain to create this site substantially into the mountain, which, as you would go into a mountain and up to dig out this thing, you're going to have not a 5-foot retaining wall. That's really kind of a joke. If you look there, and it would be 20 feet, 30 feet tall, just to try to retain the mountain on that slope, that steep of a slope. and to create a pad big enough for a 5,000 square foot pad and driveway. It's a big house that they're proposing. It's not the visual impact of the house itself. We have no idea what the house looks like or would be intended to look like. It's the cut into the mountain that would be quite visible, probably all the way to I-25. And the house would be in that cutout without a lot of reforestation and caution given to the actual bulldozing and regrading of the mountain. It would look very scarred. It's not a small scar, it'll be a huge scar. So visual impact analysis, which I believe is required for building in the higher levels of the mountains at that slope rate of the 30% slope, is required with the white story pole, so you can kind of get a visual of what it would look like from a distance. And I think the SLDC was intended, part of its goal was intended to preserve the beauty of the mountains around Santa Fe and around this area. And that should be considered when these variances are being requested. The regulations were created for a reason, 2016, whenever that was, and granting any variances is a serious thing because you're basically trying to recreate the law, right? With one variance, you're going to say, okay, well, I guess these weren't as important as we thought they were in 2016, so let's grant one variance, and that leads to someone else wanting a variance. And I'm not sure how many variances you've done, but I know you've used good judgment to do so, and we hope that you do the same in this particular instance to give it serious consideration. We're not all here because we want to come here and complain, or I have no gripe against Mr. Olson. I don't know the man, but we are concerned about protecting our neighborhood, our mountains, the beauty of the land that we have chosen to live in. I built my house on my site because it was a good building site. It was level. It was something that was you can't even see my house. Is hidden on a flat area. So if Mr. Olson happened to have bought a property that really wasn't meant to be built on, or maybe he acquired this property for another reason through a quitclaim, I think that it's not a hardship. It can't be considered a hardship for him, having known that there was going to be a difficult deal there to build on. I request that the visual impact analysis be done and a building area analysis, if it hasn't been done, that's normally required for houses above 7,400, for building sites above 7,400 feet in elevation, that be looked into as well. I agree with my neighbors. We have lots of concerns. I ask that this not be rushed into making a decision without serious consideration of all the aspects that we brought up. I did submit a letter to you as well, to John, email, and I appreciate your time and your consideration on this matter for our concerns.
Thank you, Mr. Ernest. We appreciate your testimony.
Okay, thank you very much. Looks like I see Elizabeth right now. So that's what I think that's right.
Welcome. Please identify yourself, and we'll have you sworn in, and then you can testify.
All right, thank you. My name is Elizabeth Terhune, and I live at 99 Coyote Mountain Road.
Raise your right hand. You swear affirm the testimony about to give us the whole truth.
Yes, ma'am. I'm a little bit nervous. Actually, I'm a lot nervous. So I'm going to read what I wrote. I will just only have 3 points, so it won't be very long. Construction will require workers and heavy equipment that could very well damage our fragile road. Where is the owner's intent to involve the community on the plans and a financial bond to repair any damage to the roadway and the private security gate? Those are 2 concerns. Point number 2, blockage of the roadway, and I'm very concerned about this. The roadway at the proposed site is extremely narrow and is at a steep switchback curve. I am one of the owners that lives above the switchback, so I know this curve very well. In fact, on Tuesday during the snowstorm, my neighbor came home at 1 o'clock in the morning, and she was not able to get up to her home, and she slept in her car. And I went down the next morning and tried to dig her out with my ATV, and I have a picture of the road at that time if anyone would like to see it and see the slope of it. I could show you that. The roadway cannot be blocked for the 4 lots above. Daily travel, emergency vehicles, we have UPS drivers, propane deliveries, just guests, just ordinary traffic that comes up there. And that switchback is very tight and it's very steep. So if you lose your momentum going up the hill, you're not going to make the curve. And the proposed site is directly at the curve. So I don't understand if there's been any plans made on how they're going to even commence with the construction, because it's going to block the road totally. So it is a private road, and so being that it's a private road, and the reason we have a gate there is for security reasons. That gate was put in by ourselves and another person up above, and it's very important to have that gate there for security reasons. We're there alone. Some women are there alone by themselves, and before the gate was installed, there was a lot of unwanted personnel that would go up and down the road, and they would build campfires up there. So the gate has been pretty awesome for the whole neighborhood, not just the people that live beyond the gate. Property boundaries. Whose property has granted easement to the switchback curve? Which property owners have easement rights to use or cross the switchback at that point? Last year, Mr. Olson hired some surveyors who placed a whisker stake approximately 13 feet beyond the switchback curve. That stake is still there. It was there the other day. I went up and checked it. It's been buried by the snow, but it's still there. That stake indicates to me that the property boundaries and perhaps the closest point to the road of the 22-acre parcel is at that point. But like I said, it's still about 13 feet beyond the road. In conclusion, there are many legitimate issues that affect the community and the mountainside. There's issues that I think are beyond just the variances that have been addressed and that have been asked for, that people really need to think about. That road is narrow, starting with Michelle Kirk's. The road down below is wider, but once you get to, I believe her address is 49, it just narrows into 1 lane. So you go 1 lane, and then you turn, and you go up, and you have another turn, and then there's the security gate. And you have to stop at the security gate to call so that we can let you in. Or myself, I have a clicker that I can get in and open the gate before I get up there, but it is very steep. And so you go up the hill, you get to the turn, and that is exactly where the site's going to be. Here's the road, here's the site, and the property goes this way. And you've got to use the whole curve in your vehicle to get up the road, and it's steep. So I don't understand how Mr. Olson is going to start his project with construction bulldozers, trucks, whatever, because he's going to block the road. He can't block the road. That's the only way. And this is the only entrance and exit for the 4 lots above. There is no other entrance and exit. We just have to come down on there. So That's all I have to say. I'm very nervous. Thank you so much for being. Any
Thank
questions?
you very much. You did very well. We appreciate your
Oh,
testimony.
Thank you. I actually have a picture if you'd like to see how the road is. How,
At this point, I think, I don't know how we would get that into the record.
Oh,
So
okay.
we'll just leave it as is
okay.
for now.
All
Thank
right.
you.
Thank you. No, okay.
Hi.
Please identify yourself and then we'll have you sworn in.
So I'm Jim Terrian, I'm Elizabeth's husband. She's here for my moral support. Everybody calls me JT. My friends call me JT, so you may call me JT, sir.
Do you swear affirm the testimony about to give the whole truth?
Yes. I think there, I have a bunch of summaries I'd like to go through, and I'll make it brief. But I think what the essence of a lot of this is that where none of us are experienced in this, we're not lawyers. I'm an aerospace engineer. You've heard from a variety of folk. But I think what hit me hardest is hearing that probably this was meeting, I had to fly in for it. I'm happy to be here. And then 3 weeks from now, we're going to have another meeting, and it sounded from what we could hear is that would be decided. I think the idea that it's being decided in 3 weeks, then it's not exactly sure what we're deciding. If we're deciding on allowing for variances, but then there's a whole lot more to go, or is this it? And on the 22nd day, there's going to be a bulldozer going through our gate. So that's kind of the essence of what rallied us all. And you heard that the sign was not visible to most of the people, and thank goodness to one of our neighbors who notified us, and then we were able to get the folks together. So if I may, you've heard that my wife and the proud owners and residents, the members of our community. You've heard of community often. We are a community, and we're proud of it. There's unanswered questions, and there's just real grave concerns about the planning and these variances subject by Mr. Olson and his land development consultant, James W. Siebert and Associates. Our property is at 99 Coyote Mountain, so we're at the top of the mountain, and our property borders the top of the 22-acre parcel. So I'd just like to add a few facts to this whole thing, and I'll make it as brief as possible. But what's interesting to us is that the property owner is not Mr. Olson, it's actually Amethyst Land Company, Inc., and it's as noted in the letter that we all received, that is owned by Mr. Olson, but the posting says it's Gerald Olson. Seems a little fishy to us, that this little bit of deception is it's a corporation that is the owner of this, not a person. We are, Elizabeth, my wife and I are very aware of the details of the 22-acre parcel, and we're very aware of Mr. Olson, as he, through Amethyst Land Company out of Moriarty, New Mexico, they sued us in 2006 over an easement extinguishment that we placed on the property with our lawyer. It was a lawsuit that we spent a lot of money, and it was like 8 years of going through the courts. It finally actually went to the Supreme Court here in New Mexico, which excited our lawyer because a very senior gentleman had never been to the Supreme Court. So I guess I was excited too. It's case number 34083 that we won. There's a number of noteworthy, some of the facts I think I want on the table. There's a number of noteworthy ownership deed transfers that are related to this 22 acres. And it all started back in July 10th, 1981. And there's a book, 423, pages 748, 751, if you like. But it's where a grant of easement was requiring the owner of our eventual property. We have 5 acres. Our eventual property was Mr. McDuffie. In that grant easement of 1981, it was stated, and I quote, "Never extend the easement of our property, 5 acres, to other properties," and other properties would be including his 22-acre parcel. So this fact and some other facts surrounding this original, there's actually a 60-acre parcel. This is back in the late 80s. There was a 60 parcel acre that we're 5 acres of, and then there was a separate 22-acre. And then that 22-acre, from our review of things, was not intended for the use of the road. And it was not intended for specifically what I just quoted, in that we were not, once upon us owning the property, we were not able to grant an easement across the common road that separates our properties. And so with all that, and with our lawyer involved and all, it's somewhat questionable if that road even, any part of Coyote Mountain Road even serves this property. And you've heard of that from our neighbors in some cases, who owns the corner, you know, where's the property line? I researched it some. I think it's about 15, 20 feet missing of the property line. There's a drawing on the board over here that appears like it's the entire curve, which there's no way in heck that's happened. So I'll get to a question that basically we're not sure that that road even supports the 22 acres. So in that 5 years after we bought this, so that was leading up to it. In the 5 years after we bought the property and we built our home, there's some other very noteworthy ownership deed transfers that continue to adversely affect the 22-acre parcel, soon to be, and I quote, given to Mr. Olson. And I emphasize given. It appears that none of these transfers that we have access to, and we spent a lot of money in the process of the lawsuits, and even of late, they don't mention any access of Coyote Mountain Road, which is just odd to me. So I'll read a couple of them. So on January 2nd, 2001 is when we bought our property. So 2001, we bought our property from a Mr. McDuffie. He owned our land, 5 acres and more, and then he owned the 22 acres. So he had the rights to both sides of the issue. 2 months later, on March 20th, 2001, the 22-acre parcel was special warranty deeded, transferred to a group called Desert Sunrise, LLC. A couple years later, there's evidence that's in the books is that Mr. Olson is the attorney, or was the attorney, or still was, or could be, but is the attorney for Desert Sunrise. So Mr. Olson has affiliation with what was going on in 2001, 2003. And there's a court case that shows Mr. Olson as the Desert Storm's attorney. On April 24th of 2003, a couple months after that, the 22-acre parcel was quit claim deeded, given to Amethyst and Mr. Olson. And those that don't understand or don't know what a quit claim deed is, and our understanding of it is it's a transfer of the interest of the property, and there was no money. So there is court paperwork that uses the word given, and I emphasize that. So he, in our opinion, he paid no money for it. 3 years after that, we were then sued. In September 28, 2006, we were served a lawsuit. In discovery of the process, we learned that McDuffie, who's the gentleman that we bought the property from and who owned the 22 acres, he owed Olson a great deal of money. And we also learned that Mr. Olson was on the telephone when we were out of town calling in to make the offer in 2001 for the purchase of the property. And we stated at that point, and it's in the records, that we would not buy the property unless there was that the 22-acre parcel was extinguished from using the land, the roadway up towards us. Not the entire road, but just that roadway that was in question. As evidence than what we'd read earlier, and as evidence we'd heard that he was going to put 4 to 5 building sites on it. And we would be looking straight down onto this 4 to 5 building sites. So with that, and then the discovery, we did our homework, and we looked through it, and 5 years later or so, we then get the lawsuit, and then we go through all that. So the point of bringing all that up is, and I strongly make this claim in honesty and under oath, Olson knew in 2001 when he was on the phone call that land at the top of the mountain did not support, he was not going to have access to that upper property. That was our stipulation, that we would extinguish the land when we bought it, and he was on the phone and he knew it. So thus he doesn't have, and he knew in 2001 that he did not have the site. Further evidence, he actually wrote in August 17, 2003, he wrote to our attorney talking about the extinguishments, and he admitted that he was going to ignore them. He was going to ignore the 1981 one. He was going to ignore the one that we had put in when we purchased. This all was pretty clear to us. It was a 1980, he didn't want to honor he wanted the top of the mountain. There was no question. So today, just going through a few more summary results of what we've had. The first issue that I have is basically the mistruth that I feel that was in the Siebert 2019 letter that Siebert organization sent to the county. And we heard it earlier after it was repeated, and thank you for repeating the first part of it we couldn't hear, but the words were, due to litigation, the applicant Olson cannot gain access to the ridgetop areas and is forced to build at an altar site. Mr. Olson knew for 13 years that he could not build at the upper site. It had nothing to do with the start of the litigation, and it had to do all along through the litigation. But being the fact that when he was given the land in 2003, he knew he could not build at the top of the mountains. So the best of our knowledge, he's never paid to the upkeep. You've heard that. He's never paid for the security gate. He doesn't appear to be any part of the Coyote Mountain. We have heard and know in fact that he was going to build 3 to 4 lots to sell. I think what you heard in summary is there's some rush to judgment, especially you heard about, the development over 7,400 feet, some of the analysis that are supposed to be built, the building area analysis. We haven't seen any of those. We all have the ability, and we did read SLDC, but especially the 717.10. There's a number, there's 8 analyses that are required. All we're hearing about is about 4 of them, and we're being asked to consider variances to those. One thing that I think bothers myself and others is that there was a passage that's in Siebert's 2019 letter, and I'll give you 2 quotes, and that was the 2019 letter to y'all. It says, after several meetings and discussions with staff, it was determined by the administrative staff that the proposed location was an alternative area suitable for the construction of a residence. Second quote, it was also discussed that the alternate location chosen by staff would receive a positive recommendation for variances needed moving forward. I guess the question would be, how are we supposed to interpret that? It sounds like the county, I believe the staff has already made their mind up. That bothers us. 5th item I want to bring up is in the Siebert letter to Olson. Actually, I haven't mentioned this one yet. So back in August 11th, 2003, it was Mr. Jim Siebert. I believe I'm sure he's the owner of Siebert and consultant James W. Siebert. So he actually wrote in August 11th, 2003, he wrote a letter to Mr. Olson, and I would like to give you 4 quotes on that. The lot has a, singular, buildable site, although it is located within a designated ridgetop, so i.e. there's only 1 spot. In this case, there is no other reasonable location for a home other than within the ridgetop designation. His words, Mr. Siebert. Another quote, Paul Kavanaugh, at that time believed county land use staff field inspector, I believe he's still on the staff. He's quoted as saying, we'll verify that no other reasonable location exists for building other than the ridgetop. Pretty strong quotes back in 2003. And then the 4th, actually in the Siebert 2019 letter, it actually says in this case there is no other buildable area on the property. So it kind of bewilders us is that we're here to talk about another spot, but I've given you 4 quotes that in their words, there is no other buildable spot on that property. So in light of that, how all of a sudden is there a buildable site? I think you've heard that from a number of people, which that's part of our concerns. Then there's the questionable lower access. We talked about it a little bit. I think there's facts that say that road doesn't even serve that 22 acres, let alone the curve. As my wife had mentioned, it's the steep switchback curve where the construction would start. So I guess we would ask the county to provide us the details that say the survey of a recent survey. I took the cadastral dimensions of this thing back in the lawsuit days. I plotted it out with 6-point decimal accuracy on AutoCAD, and I can quote the numbers I found. So maybe there's numbers and problems with past surveys. Maybe new surveys have new techniques, but I question why all of a sudden there's drawings on the board here that show the entire curve is covered when there's another picture that we received that shows it kissed it, and I believe it misses it by 18 feet. So that's the questionable lower access we speak of. So I guess I would ask the county to provide those kind of details in the process of all this. The provision, you've heard a little bit about the provision as you write on your notice that, quote, property owners within 500 feet of the 22-acre parcel and community organizations and or registered organizations recognized by the county are required to be given fair notice by first-class mailing. We did send a couple phone calls in, did not get answers, but I know we've all been busy, but we would like to know who received the list, who it was sent to, And we'd like to know especially who are the interested organizations. I mean, those things, you've heard a number of our neighbors did not receive it. There's actually 4 pieces of property that are within 500 feet of the boundaries up above to the right and to the east and the northeast. I believe they never got it. That doesn't seem right. Last page. For the 4 stated variants, I'll say it in a different way than you heard a few minutes ago, but it's asking for violation of well-established and well-intended county legal standards. No mention of the upper limit. So it's one thing to vary, to exceed 30 degrees slope. Does that mean they can go to 31, or does that mean they can go to 75? I think that needs to be quantified, in which there's no evidence of any quantifying the magnitude of the variance. What about these other standards and considerations? Maybe you'll all approve that I'm not right, because my research is my research, but I believe there's an entire SLDC that has issues that are more beyond the 4. I looked up the EZA, the Extraterritorial Zoning Authority. That seems to play into it because we're in view of, you will be in view of I-25. So that seems like we're within that zone. MSRD, if that still exists. When we bought our property, we had to deal with the Mountain Special Review District when we bought our property, and we built on the flat slope, but we were limited to the size of the property we had. We were limited by view from Old Santa Fe Trail. We were limited by view to the I-25, and so we were and we actually had to do a little change because one of our walls was longer than 10 feet flat surface and all, and we had to knock it out a little bit, but we met all those requirements. But we didn't have to take out big significant trees. We didn't have to take out significant boulders. I think my wife Elizabeth, historically, if the county variances are approved, then I want to add, how are they policed? What is the violation? What's the penalty upon violating the agreements? It's a little late after they've already exceeded the 10 trees or the 1,000 trees or whatever the plan says. It's a little late to bring those back. So what is the process of policing these variances as we go forward? I had drawn up and I'd sent to you a picture, a 30% grade. So let me try this. This house, drawing it up, I picked it up and drew it up and exploded it out. It's probably about 65 feet in the depth of the cut, and double that to the width of the cut based on the defined 8267 square feet. If you were to take 65 feet starting at a flat surface at the low side of the hill, and you dig 65 feet straight into the hill, at the limit of the 30% grade, you're at a 19 foot high wall. So we're not sure what this 5-foot wall thing we kind of heard about, but as soon as you start exceeding it, 30% is 19 feet, 20% is 26 feet. This thing could easily we've walked it. 50% grade. This thing would be like a 32-foot retaining wall without a building. That's going to be visible from the space station. So I think part of the concern we've heard, this is not about a building. This is about a building site, but that wall, it could easily be 20, 30, 40 feet. How's that going to be handled? And there is another variance that I found in SLDC that has to be painted. There's certain stipulations of what that view is. It's not just a building, but it's on, I looked at the word wall. So in conclusion, I think that we believe that all New Mexico landowners do have a right, his or her rights, to put up and build on their property. But we need to slow this down and get proper posting, the proper evaluation of all requirements. I don't believe I found every one of them. When I found 4 acronyms of SLDC, MSRD, EZA, I can't imagine there isn't another one. But I believe I can speak, wholeheartedly across the board. The residents of Coyote Mountain Road and Coyote Hills, we really do want to demand a disapproval of these variances until further notice. And just in quick, rapid summary, there's this disrespect for the value and the purpose of sustained land code. So if there's such a thing, why do we have a code if there's this flagrant variance being entertained? Second, unquantified amount of disturbances and permanent erosion damage. You heard that. Third is unacceptable and unquantified tree, shrub, and vegetation removal. Fourth is unlimited planned exceedances of code variances, as I detailed. Fifth is damaged, already fragile private road. Sixth, inefficient engineering, environmental, and historical culture analysis. Limited water resources, visual aspects of the huge cut, and then just the inaccuracies of the depiction of this necessity, the urgency, and the undue hardship on the owner. I've already expressed my opinion about that. He gained this property, and he knew about the limitations of it upon being gifted the property through a quitclaim deed. So therein is what we're curious about. What are the next steps? And we really would request that the next meeting or hearings be held at the proposed building site. Come out to the building site on the mountain, put your boots on, but come out and see where the true impact would be and witness it. And it's better than pictures and whatever, but we would really appreciate the next meeting or so to be up on the mountain. So that's all I had.
Okay, thank you very much. Are there other members of the public that wish to testify?
I think that was it.
Okay. Seeing none, I'm going to conclude the public testimony portion of the hearing at this point and ask the applicant to respond to the public testimony, and then I'm going to ask the staff to also respond if they want to.
Thank you, Mr. Hearing Officer Virtue. I would like to just to answer one of your questions. I don't remember this gentleman's name. JT. The only acronym you need to be researching is SLDC. Those other codes don't exist anymore. I'm going to touch on both those letters that you were. I want to touch on two of those letters you were referring to. We're talking about two different codes. One, talking about the Land Development Code, which allowed you to develop on ridgetops. And we're talking about the SLDC, which does not allow you to develop on ridgetops unless there's another buildable area on the property. So that's why you have those letters with two conflicting kind of decisions regarding the ridgetop and buildable areas. I do have this plat from 1983 that does show access to Mr. Olson's property. So I want you to take a look at that as well. And that is the same as our plan here, which you can see this corner runs well into Mr. Olson's property.
So just to clarify for the record, Mr. Dalton, are you referring to NBA 17 that we were talking about before? Is this a new document?
Mr. Hearing Officer Virtue, that's a different document that was not included in your staff report. That's actually the plat of survey. So
okay, well,
we can have, if we can make a copy of that, you can enter that in as an exhibit.
Let's do that. Let's make a copy and mark it as a hearing exhibit. I believe it would be hearing exhibit 2. Is that correct? Is that right? Yes. Okay, and we'll enter it into the record as hearing exhibit 2.
May I respond slightly?
Also,
if there are no objections, people have the right to object to putting it in the record.
I want to just clarify. We've seen these pictures. We've seen them in 3 different varieties. I would like to, what I asked for specifically is take the PLSS cadastral data.
Could we get you on a microphone?
Across the mountain. So all I was asking for, I have seen pictures of this. I've seen every variety of it. And it's not actually accurate because there's a notch up here that was taken out also, which isn't shown. All I'm asking is the PLSS data, the cadastral data be replotted. That's survey data that I have access to, you have access to. It's clear. I know how to plot it. It's go up this distance, turn left and 86 degrees and go up 400 feet and turn left. It's plotted. There's issues with this. And I have it of that land, of the 22 acres, and I have it of the road and the center line of the road. And there's a 40-foot, 20, so that's all I'm asking.
Okay, well, just to clarify, I concluded the public testimony portion of the hearing, and I'm allowing the applicant a chance to respond to the public, and I didn't allow them to interrupt you. So let's let the applicant continue with their response to the public, and then we'll go from there. Okay. But I am going to admit the plat as hearing exhibit 2. If we could make copies and make sure I and the recorder get a copy.
May I continue?
Proceed.
Thank you. Hearing Officer Virtue, I also want to state for the record that noticing requirements were fulfilled as per the SLDC. The SLDC does not require a neighborhood meeting in this case. There were approximately 34 letters sent out. The registered community organization was Santa Fe Association of Realtors, care of Donna Reynolds, 510 North Guadalupe, Santa Fe, New Mexico, 87501. That was sent by first class mail. There are no registered ROs in this area. Therefore, no letters were sent out. As far as everyone's concerned, Hearing Officer Virtue, I believe all their concerns can be addressed at time this moves at the time if and when these variances are granted by the Planning Commission. And at the time this goes for permitting, there are strict requirements and guidelines set forth in the SLDC regarding drainage and grading, stabilization, landscaping. There's some big reports that staff is requiring within these conditions of approval that we're accepting. And it just doesn't make any sense that all these reports are done before, like I said, we know these variances are going to be granted. Like I said in the beginning, this is a legal lot of record. And Mr. Olson is allowed to have a residence and a driveway on his property. We did not choose this site. The site was chosen for us. And that would conclude my response to everyone's concerns. I just want to let everybody know we do hear your concerns, but I believe that staff will do their due diligence in addressing your concerns, and so will we. Thank you.
Okay. Thank you, Mr. Dalton. Does the staff have a response to the public testimony and the applicant's response?
Hearing Officer Virtue, after hearing concerns, they make irrelevant points, and staff has taken consideration on all these points that they brought along. When you look at the site, without any variances, this property cannot be developed. The way the staff's position on these are, we have to grant them, but they have to go through the procedure process, which would be the variance process. Was in staff's opinion that this location causes less scarring than a road going up the entire face of this property. With that, on top of that, a ridge top. And then you have that visual aspect of it. As in terms of visual impact analysis, staff feels at the time of building permit that is going to be necessary. But in that essence, this project, whether you put it on the ridge top or on that side of that slope, it's going to be visual, and they're going to have to mitigate that visual impact in some sense or another with landscape, whatever it may be. Going back and looking at your drainage issues, staff has reviewed or has taken that into consideration. We have that as a condition of approval. Pre and post calculations cannot increase when you develop a property. They will have to do a drainage analysis. They will have to do a drainage study and a grading and drainage plan to ensure this, as well as the stabilization plan or any cuts they may do. In terms of, if you would turn to Exhibit 2, and you actually look at section cut C-1 on the bottom right-hand corner, you'll see that it's not a vertical cut as some people have claimed it to be. This is actually stepping up in essence. They have to maintain a minimum height requirement of 18 feet with an overall height requirement as well. So it's not a vertical cut going straight up this slope. When you look at division of the property for this property, no further development will be allowed on this property. There is no other buildable area. Staff does not grant buildable area on a property that has slopes in excess of 30% slope. The request for variances on 30% slope, while this slope might be greater than 30% slope, our requirements go up to 30%. It may be 45%, it may be 40%. It's just, that's what we have to go off of on a basis. So that's why they are requesting these variance requests. In terms of significant trees has a certain criteria on what is significant and what is not on 30% slope. It may be inaccurate. Staff can verify that. Mr. Dalton has touched base on reaching out to the public in the community. They are not required a public community meeting for this. They are required first-class mailouts, and any ROs or COs that may be required to be noticed will be sent out as needed. This did not require any of that. In terms of the property boundary, we have the survey plots as you placed as an exhibit, and we also have data from our assessor's office, which shows the same ordeal that we have here, and they basically go off deeds and meets and bounds, and that's how they create parcel boundaries. They may be off a foot, they may be off 2 feet, but I've never heard in any case that they'd be off more than that. And noticing issues have been properly done as far as what's been asked of the applicant. But any further questions, I would defer over to Vicky Lucero for anything that I may not have covered.
Hearing Officer Virtue, if I could just go back and clarify a few things. So this request for a variance, just wanted to clarify that this is a recommendation that will occur here today. This hearing is a recommendation. It will go on to the Planning Commission, and they'll have final authority. If the variance is granted, the applicant, basically what that does is it gives the applicant the right to proceed with the development permitting process. So they're not going to go out and have put out a bulldozer, the day after the Planning Commission makes a decision. They still have to come in through our permitting process, which would require a grading and drainage plan, rainwater harvesting plan, a review by the fire marshal's office. We conduct a thorough review to make sure that it meets all of their code requirements and that it meets the conditions that we're recommending be imposed on the variances. So we make sure that it is consistent with whatever variances are granted. There were some other issues that were brought up regarding contributions to road maintenance and gate maintenance. That's not something that the county enforces, so that would be something that would get enforced through the homeowners association or the maintenance road maintenance association in that area. Let's see. I think that was basically all that I wanted to add to Mr. Lovato's statements, and we would stand for any additional questions.
Okay, I would ask staff if there's anything that the public testimony raised, any issues raised that you think you would want to discuss further with members of the public before considering whether to revise the recommendation, or do you stand by it at this point, having heard the public testimony?
Hearing Officer Virtue, I think staff would like to see the documentation from Mr. Terhune regarding the easement. I mean, we have the plat that we've reviewed, that we've looked at to determine that there is legal access to the property, but there may be some documentation, or sounds like there's some documentation that we may not have. So we would like the opportunity to analyze that.
Mr. Terhune, can you provide your?
Yeah, I have the PLS coordinates, and I'd be happy to document them for the 22 acre and the center line of the road, which then has 20 foot on either side, is required for the 40-foot easement. And those are the dimensions I was referencing, but I'd be happy to provide those. And I'm sorry if I interrupted earlier with, but we've also heard, the surveying, the state of New Mexico wasn't always all that, tight and everything else, but it's always an amazement that, you got some numbers that are documented and, you can plot them and then you can go find things that are drawn. And then I overlaid them actually on Google Earth with, I have access to some special satellite terrestrial stuff, and the road's right where it says it's supposed to be, and the road didn't move, and so I'd be happy to provide all that to Mr. Lovato. Yeah.
Okay, can you do that within 7 days, within a week?
Yes, sir.
And do we have is there a scheduled planning commission hearing for this variance at this point?
Hearing Officer Virtue, I believe the Planning Commission meeting is on March 19th. Yeah, I think that's correct.
I have to note it.
Okay.
Okay, so does the staff believe it can, if it receives the information from Mr. Terhune on the access, you can make whatever revisions that are necessary and be ready for the Planning Commission meeting on the 19th?
Hearing Officer Virtue, our packet material and our staff report would have to be prepared a week before that, so that only gives us a couple weeks. So we can certainly try, but depending on what, we may have to do additional research on our end and maybe get with our GIS staff to do some additional mapping. So.
Yeah, I understand. That's why I was asking the question, whether you're going to run into a little bit of a log jam there, considering the additional information.
If there isn't an opportunity to get that done prior to the Planning Commission meeting, then what we would request is that the case be tabled until the next regularly scheduled Planning Commission.
That sounds like a reasonable way to address that. Okay, so that you understand, Mr. Terhune, I'm going to make a recommendation based upon this hearing. It will go to the Planning Commission, and then there'll be another public hearing at the Planning Commission, which will include consideration of the access issues and any recommendations I have on the hearing today. So the neighborhood and members of the public will have an opportunity to consider my recommendation, present your concerns with my recommendation to the Planning Commission. So this will not be the final word on the matter. It will proceed to another public hearing, just so you know that.
All right, I do.
Okay,
Thank you.
Okay. One additional matter is that the letters that the members of the community sent have been provided. Were they provided to the recorder? Okay. I'd ask the recorder, let's identify those as hearing exhibit 3. And if you would attach those to the transcript of the hearing, please, and identify them so we know by date and the author, so we know exactly what they are, and we'll put those in the record of the hearing. Okay. Does anyone have anything else that they would like to come before the hearing at this point? Yes, sir. Go ahead. Mr. Terhune.
So I would ask that the county go back and research the easements that I've referenced there. And I can give numbers over if y'all want, but The 1981 easement clearly said that upper property of ours and the land above it that did not give access to the 22 acres. So I believe that when he received the property, when he was part of all that process I described, that the depiction of that upper property being the only buildable site, it's clear at that point he was going to have to go across the face of the mountain, switch back a few times, as Mr. Lovato mentioned. I mean, that probably was ugly, but he does have access to that upper site. It's just not through the road that he keeps claiming that it was the lawsuit that caused it. It was the easements that caused it. And he bought into that when he bought the property or received the property. So,
yeah. So that's documentation that should be part of what your submittal that will come in a week. And then I'm going to ask staff and the county attorney's office to make sure that gets reviewed and a report be given to the planning commission on that documentation. Okay.
so I'm clear. I'll give over the book and page numbers that are described as the easements. Everything I've got on that. Yes, I will do
That's
that.
correct. If you will do that,
Yes, sir.
then we'll have the staff and the county attorney's office review it, and then they'll make a report to the planning commission on that.
Yep.
Okay.
Yes, sir.
If there's nothing else to come before the meeting, I will declare the meeting and the hearing concluded, and I will make a written recommendation within 15 working days of today. Thank you.